joining us today. We'll just give a few seconds for everybody to get in. All right. Well, thank you for joining this webinar, Landlord Strategies for the Pandemic Real Estate Market, brought to you by Venable and MGO. I'm Tim Wells with MGO, here to moderate today's discussion. Most of you joining us today either own or provide services to owners of the commercial real estate market. And you know better than most that the commercial real estate market is acutely affected by this pandemic. Over the next hour, we'll share some contemporary strategies and insights that can help you overcome the challenges you are currently facing. But first, a few housekeeping notes. We encourage you to participate. To ask a question, click the Q&A button on your screen, type it in, and we'll do our best to get to it during the course of this webinar. If we don't, we'll be sure to follow up afterwards. Finally, a brief disclaimer, this information is not intended to provide legal advice or opinion. Such advice may only be given when related to specific fact situations that Venable LLP has accepted an engagement as counsel to address. Same goes for the financial side. This should not be taken as direct financial advice. Now let's get to the two firms and the panelists. MGO is one of the fastest growing accounting firms in the country with a suite of assurance, tax, and advisory solutions, including forensic advisory and litigation support, and our recently announced lease administration solution. We also have our affiliate, MGO Realty Advisors. Venable LLP is an American lawyer global 100 law firm that serves as primary counsel to a worldwide clientele of large and mid-sized organizations, nonprofits, high net worth entrepreneurs, and other individuals. With one of the leading real estate and litigation legal practices in the United States, their team blends teamwork and creativity to serve clients in every facet of contemporary real estate transactional and litigation activity. Now let's get to our panelists. First up, Caroline Gately, a partner at Venable. Caroline is a commercial trial lawyer and the chair of Venable's commercial litigation practice in the Washington, D.C. metropolitan area. Her practice focuses on real estate litigation. Since the beginning of the pandemic, she has closely tracked and advised clients on evolving landlord-tenant issues and has written and spoken on those legal topics. Next up, we have Jill Rowe. Jill is also a partner at Venable. She has been litigating and advising her clients in commercial real estate matters for over 20 years. She consistently resolves thorny problems for property owners and real estate brokers in buy-sell disputes, landlord-tenant claims, title and easement actions, and all manner of commercial real estate issues in between. Now to MGO. First up, we have Francisco Colon. He's a partner with MGO and leads MGO's transaction advisory and assurance services practice. He has extensive experience in external audit, fraud examinations, litigation support, and buyer-seller due diligence. He's also a certified public accountant, a certified fraud examiner, and a chartered global management accountant. Finally, let's get to Rodrigo. Rodrigo Macias is a partner with MGO. He's our advisory services practice leader. His focus includes risk advisory, forensic accounting, transactional advisory, and management consulting services. He's also a certified public accountant and certified fraud examiner. So let's get straight into the questions. And we'll start with Caroline from Venable. Caroline, what are you seeing right now in the commercial real estate market?
Thank you, Tim, and thank you for hosting us, and thanks to Rodrigo and Francisco of MGO for collaborating with us on this interesting topic. I'm thrilled to be here today with the clients and friends of MGO and of our law firm, Venable. So in the beginning of the pandemic, we saw what everyone else here probably saw. A lot of uncertainty that led to either a momentary paralysis or short-term measures with a wait-and-see approach to decision-making, on the assumption, of course, that this interruption was temporary. Now, however, we are seeing the next phase of the decision-making process for landlords. Some of the economic impact is now either permanent or long-term, and emergency relief in some states entitles tenants to rent relief or gives them defenses to non-payment of rent if they can demonstrate the financial impact of COVID on their ability to pay rent. So as a result, what we're seeing now in this phase that we're in currently, landlords have to engage in thoughtful and deliberate financial and risk underwriting, and they are more open to cutting deals from what we're seeing. That financial analysis must be coupled with an understanding of market conditions, which my colleague Jill will talk with you about next.
Jill, you may be on mute.
Thank you. I think the analogy that is coming to me during this time is that of a three-legged stool. For commercial real estate, you've always had three legs of the financial piece and your financial advisors. You've had the legal piece with your lawyers, and you've had the real estate market piece with your brokers. And in decent times, sometimes one of those legs will get a little bit wobbly. You might have a tenant who goes out of business. You might have some market conditioning happening in your market. You might have some legal issue arise. But right now, all three of those pieces are wobbly. And so right now, what we are seeing more than ever is a team collaboration effort between the financial people, the legal people, and the brokers, a lot of whom are watching this call today. Thank you for joining. I was really excited when we started talking with MGO about this idea of teaming up and presenting here today, because that three-legged stool is more than ever what you need. You need all three of those pieces working together. What we're seeing is specifically in the different commercial real estate markets, and I'm just going to go quickly over the three big ones of offices, retail, and multifamily. In the office market, I think this is no surprise. What we're seeing is no direct leases being signed right now. We are seeing some subleasing activity. We're seeing tons of subleases coming up on the market, a few of those being taken, but so far not a lot of direct leasing activity. I think there's still a wait-and-see approach in terms of the landlords wanting to see what happens. In the retail market, sort of similar things. We are obviously seeing a lot of vacancies. We're not seeing quite as much non-payment of rent as you would expect, but we're seeing a lot of retail tenants allowing their tenancies to terminate and then moving out after that. One little tip that I'm hearing, if you happen to be in the restaurant space, is that I'm hearing that restaurant establishments are really reconsidering what kind of space needs they have. I'm hearing that anything with a drive-through is very hot right now, and smaller spaces are being considered even by larger restaurants, particularly the fast casual market, is what I'm hearing. And then the third piece, the multifamily housing, if that's the market that you're in. So far to date, despite the initial predictions, rent payment has been relatively stable, but the predictions are that that's largely due to the fact that there was extended unemployment insurance and some stimulus payments that have now run out. And so people are anticipating more defaults, particularly in the Class C rental markets and suburban markets. The other area that's taking a big hit is the high-end new properties in downtown markets that have been charging very high rents. A lot of those folks are moving out and learning that they can work from their parents' home or something. So that's a very broad overview of what's going on across the nation. And of course, it varies from market to market, but we'll talk more about the details as we go through this project. Tim?
Gotcha. Rodrigo, kind of same question to you. What are you seeing in the commercial real estate market right now?
Absolutely. Thank you, Tim. Also, we're really glad to be here. Thank you, Jill and Caroline, for having this webinar with us. So from our side, what we're definitely seeing is landlords are truly trying to seek to understand the financial impact that COVID has had on their tenants. So they're looking into having those proactive communications related to what financial information do they have, what information, how has COVID truly impacted their operation, how they're moving to strategize and change operations in order to innovate, in order to really re-strategize and come out of the downturn faster. On another note, truly landlords are looking internally. They're looking at their internal operations, trying to understand their cash flow models. They're looking historically is an industry where you see the steady income coming on a monthly basis. Now you're looking at this volatility. So now you truly are looking in regards to what could we be doing from a proactive approach in order to be monitoring that cash flow volatility. One of the areas that we're looking at is a time for refinancing, with interest rates being as low as they are. Is there an opportunity right now to actually go offer and refinance some of your buildings? This potentially could also allow for, if you have a lower interest rate, this could also allow for readjustment of those monthly cash flows. Comparison to decreasing rent, lower mortgage payments potentially could yield regular profit margins as before the pandemic. Other areas that we're looking for is the use of technology. As we have less and less employees on staff, we're looking to automate processes. So how can we use technology in order to make this rental collection, notifications, monthly approach streamlined? As well as, it's a time for do construction and lease improvements. Right now, as Jill and Caroline were talking, there's been some open spaces, so there's less traffic associated with the current building. So it's a time for actually to do construction and to perform some of those improvements. And lastly is, one of the big areas that we're seeing in regards to buildings is conversion of amenities. So historically, you see gyms or cafeterias or things of that nature being a really big selling point in regards to drive higher rent prices. But now we're seeing those gyms or those cafeterias being converted, for example, into daycares. Being a daycare being something that potentially would be, depending on your jurisdiction in the state, would be considered an essential industry. So we're seeing some of those being converted into that space. So again, it's basically just a combination of truly working with the tenants, seeking to understand their financial information, and looking internally to truly make sure that we have better operations. Tim?
Interesting. Now to our next question, which I feel a lot of folks on this webinar are probably dealing with. What should a landlord do if its tenant doesn't pay rent or requests a rent reduction? So Francisco, let's go to you on that one.
Thank you, Tim. Thank you, everyone. Again, I think the most important is understanding that there's not one size fits all. I think the first thing that, as it's been mentioned before, Jill and Caroline and Rodrigo alluded, is being proactive, how we're reaching out to tenants and understanding their situation. Are we communicating? Is that a priority? So we can address some of the lack of payment or the request for rent reduction. The next item that I want to talk about is the concept of, I'm exhibiting that I have some financial burden. How are we going to verify that? What is going to be reliable information? A lot of times we request that they provide proof, and everything starts with the agreements, drafted by lawyers. A lot of times, and Jill and Caroline will expand on this, is what we call the right to audit. Do we have the right to obtain financial documents at any time to evaluate the client credit worthiness and to evaluate points to ensure that this client is going to be here for the long term as we're making investments on the property and so on. So what we will consider reliable information, if the information hasn't been audited, are we looking for tax returns? Are we looking for bank statements? I think defining and understanding the client, what information we can receive, because there's a big difference between a tenant that has completely lost their job or their way of income because of the coronavirus versus a client that just lost 1/4 of their income. They might still be making $500,000 a month, so they're able to pay our rent. The question is, do they lost it completely or they want to defer the rent payment? So I think those are part of the evaluation process that many of the individuals on this call have to be addressing. The other piece is start gathering information if you're going to go to an eviction or that you're going to go into litigation with this tenant. Is now you have information on your power that you'll be able to use later versus having to go through an expensive case, and your accountant and your legal advisor will be able to guide you through that process. The next item is looking for solutions, asking for recommendations. Are they looking for solutions like a short-term rent reduction? Are they looking for rent forgiveness? Are they looking to defer the rent into future years? Are they going to be looking to say, hey, maybe it's time that we part ways, and understanding what is the solution that they're looking for is very important in deciding how do we move forward. A lot of times, maybe even working a payment plan, getting at least maybe not the full rent, but getting some rent will help the process, and it will accelerate to know where you stand with your tenant. I know there's moratoriums on eviction and making some adjustments to force tenants to pay right now. But I think understanding, having that open communication could be very beneficial in the long term. Thank you, Tim.
Interesting. Why don't we go to Caroline on this one as well? Caroline, what should a landlord do if its tenant doesn't pay rent or requests a rent reduction from your perspective?
Sure. So I'll talk a little bit, Tim, about the legal remedies and the options that landlords have these days in response to a tenant that's asked for that relief or can't pay, because some of those have changed in response to the pandemic due to emergency relief, which I mentioned earlier. And that relief has taken three main forms. First, there is compelled rent relief. That can be a law or an executive order that compels a landlord to give either a rent deferral, that would be with a repayment plan, to waive late fees, to freeze any rent increases. I haven't seen any compelled rent abatements, rent holidays in a general commercial context, although beware that in some specific contexts like airports, there are even some rent holidays that have been compelled. So that's number one. The second form is it can be a defense to eviction if a tenant can demonstrate the financial impact of COVID on its ability to pay rent. And this draws exactly on what Francisco was just saying. Is it a wholesale inability to pay rent? Is it partial? Were there some pre-existing financial deficiencies that the COVID exacerbated but didn't cause per se? Those are all important pieces that financial analysis makes very important. And then finally, the third form of relief is the outright moratorium on evictions. I'm sure you've all heard of them. But a couple things to note here, that a moratorium might not prevent the kind of eviction that the landlord wants to do if it's based on the non-payment of rent. And a moratorium can have an impact, but if it's based on some other thing, an expired lease, a health and safety issue, some other non-monetary covenant, the landlords might still be able to evict, but on the non-payment of rent, that's where you're seeing the moratoriums. Also, just a little bit of caution, if you Google moratoriums to see what your state's doing, they tend to focus on residential moratoriums and not necessarily on what's happening in the non-residential space. So just want to mention those few tips. The other things that landlords can do is consider what self-help remedies they've had, because I haven't seen any real effort to impact those. So applying a security deposit, drawing on a letter of credit, looking to a parent guarantee or a personal guarantee, seizing personal property to satisfy a rent obligation, and some states even have self-help evictions that might still be available. That's a tricky one and requires some counsel. But in general, there's this shifting in the balance of power away from what the landlord's ultimate hammer has been, which is eviction and backfilling with a new tenant. So renegotiation and restructuring are a lot more the topic of conversation than they would have been outside the pandemic. And my colleague Jill can talk a little bit about what those negotiations are looking like.
Thanks, Caroline. And sticking with this topic of, what do you do if your tenant isn't paying rent or is requesting a rent reduction? The first thing, you probably won't be surprised to hear a lawyer say this, but read your lease very carefully. There are lots of provisions in leases that nobody has ever paid attention to in the past, and suddenly they mean something. Sometimes they spell out who pays rent in exactly this situation. Usually they protect the landlord's payment of rent, but you need to know what your lease says. You also have to pay more attention than ever to the notice provisions in your lease. Your notice provision might be very specific and say you have to provide a notice by overnight mail to a certain particular address, and maybe for years you haven't complied with that, but now you need to be more careful than ever to comply with those notice provisions so that you don't accidentally hand your tenant an escape clause if you bring legal claims against him. I think Francisco sort of referred to the different types of solutions that landlords and their tenants are talking about. Rent deferral, they can pay the rent later. One note of caution here is if you are agreeing to a rent deferral, think very carefully about whether the repayment period matches up with the tenant's possession in the property, because it's going to be very difficult to get a tenant to pay rent if they've already vacated the property. Rent holidays, abatement have been discussed. What you guys probably all know as blend and extend is happening right now, where tenants are agreeing to stay longer in their lease in exchange for abatement or deferral. And then the other thing that landlords have a little bit more control over now is to request a letter of credit or a personal guarantee if one doesn't already exist. Tenants are awfully reluctant to give those right now, but they are certainly being requested. Alluding to really the things that MGO has been talking about and all the financial analysis that they can help you do in trying to figure out what to do with your tenant. Some leases do have audit rights, most don't. So you might have to rely on the public filings. If it's a public company, if they're paying percentage rent, you may have gotten percentage rent reports. But even if your lease doesn't compel them to provide information, if they're requesting a concession, they're going to have to give you the financial information. So you do have power to demand things, even if it's not within the four corners of the lease. The last tip that I would give to you right now is when you do come to a deal with your tenant, whatever it is, absolutely do not cut and paste from your prior leases or your prior agreements or something that you find online. Now is a time where the whole contracting world for commercial real estate has dramatically changed, because we know of certain things that used to be uncertainties, like pandemic and moratoriums, and we know there's probably going to be some financial problems. Those were uncertainties. Now they're a certain uncertainty. And what that means from a legal perspective is that you need to draft your agreements to reflect those risks. One quick example, just to let you know what I'm talking about. If you do give your tenant a rent deferral and then tomorrow a vaccine comes out and suddenly the economy is booming, are you going to get that rent deferral reversed or not? If you want it reversed, you better make that very clear in your lease. So really think about all the potential scenarios, worst case scenarios, and try to anticipate what could happen. Back to the three-legged stool analogy, this is a good time to be talking to your broker about these things, and then make sure you're specifically contracting for that in the agreements that you do work out.
Let's dig in a little deeper into eviction. For that option, what considerations should a landlord take into account during the pandemic? And Jill, let's go back to you, just because we were chatting about it. What do you have to say on that?
Well, I would start with saying, think about the consequences of eviction. Right now, there's so much uncertainty with whether you'd be able to fill that space. Are you better off with a tenant in the space at reduced rent, or maybe not even rent, but at least they're occupying the space and keeping it safe? You're going to really need to talk with your broker about what's going on in the market. Are you likely to find another tenant if you go down this path of eviction? Also, be thinking about your tenant mix. If you're, for instance, retail with a number of tenants, you might want to make sure that you still have an anchor tenant, or there might be certain types of tenants that are more valuable in order to keep your premises safe and to keep other tenants being willing to come. So think very hard about your tenant mix before you evict somebody. And then the other thing is to look at the covenants in your tenant's lease, but also in the other tenant's lease. So if you're a multi-tenant property, you want to be sure that if one space is vacant for a long time, you're not violating covenants with your other tenants. You also want to make sure that if you do have an empty space and you want to backfill it, your other leases don't preclude you from having a competitor type business. So those are things to think carefully about if you're deciding to go down that path of eviction. And Caroline's going to talk about what happens if you actually do proceed into eviction.
Thanks, Jill. So this is a little bit digging deeper on moratoriums. Moratoria, if you speak Latin. It's a moving target. In the beginning of the pandemic, there were quite a few more states and local jurisdictions that imposed them. Some have expired, some have re-upped. There have been some gap periods, but there are two pieces that you have to know about. One is what's happening on the legislative front and the executive orders front. And then separately, even if the state legislature or your governor or mayor allows evictions to go forward, are the courts open to hearing those cases? And in addition to whether the courts are open to hearing them, can you file your eviction complaint even if you can't have it heard yet or have an eviction order enforced? So there may be an advantage to getting your place in line if the decision has been made that eviction is ultimately going to be the best course of action for the landlord. So getting those pieces synchronized is tricky because it has been a moving target. Also, one thing to be aware of in the eviction, I mentioned this earlier, in some states, a tenant can defend against the eviction if either, number one, the landlord has failed to provide the relief that it is compelled to provide under the state's law, or if the tenant can come to court and demonstrate the effect of COVID on its ability to pay the rent. And again, this is where having the financial analysis is helpful, but it's also, from wearing my litigator's hat, where you can really take advantage of that information that Jill mentioned should be forthcoming when you're in deal-making mode to then defend or challenge the defense against the eviction because you're armed with information already that the tenant provided to you in the deal-making discussions. So ultimately, where you can get your place in line because you have no choice but to evict, try to hop on that train as soon as you can. Tim, back to you.
Now, Francisco, from your perspective, with evictions, what should landlords be considering right now?
I think Jill and Caroline summarized this very well. And I think from the financial perspective is have a strategy, understand what is the ultimate goal. Don't just focus on the eviction. Make sure that you're talking with your legal, accounting, and other professionals. A good thing on this is legal and professional fees associated with eviction are tax deductible. On the other hand, it doesn't just stop at the eviction. I think Jill say, you need to work through all the scenarios. The different scenarios is, do we have an anchor tenant? Do we have covenant issues? Do we have any financial covenant issues? Do we have a loan attached to the property? Make sure that you're talking with your bank, that you're involving your legal counsel, especially if they have been working on the eviction, that they can give you points to consider as you're negotiating that agreement and looking to draft a new document. Again, make sure you understand your lease, but you take it that step farther. From the tax perspective, it gives opportunities for people to do some tax planning. They're going to experience some losses. Maybe it's time to do a cost segregation study and accelerate depreciation of part of the buildings. Looking at property taxes or looking at impairment losses as a result of that eviction. So making sure that you're not just stopping at the eviction process and you're working really hand by hand with your attorneys, that you can have a longer term strategy. As Caroline also mentioned, is what are you online from really executing an effective eviction process? In that way, you know the term and how you're moving all these complicated pieces. Back to you, Tim.
Got it. And I just want to take a moment to remind the audience that of the Q&A button there at the bottom of your screen. Feel free to ask any questions. We have a few coming in, but we'd love to see some more. But let's head straight into that fourth question. How does the possibility of tenant bankruptcy affect a landlord's decision-making? Caroline, let's start with you on that one.
Sure. So I'll just make a couple high points here. The first one, you've heard it before, but I wouldn't be a lawyer if I didn't say it to you. If you know that a tenant has filed bankruptcy, you have to take no action until you consult with folks who can give you good advice on what you can and can't do. It's the automatic stay of bankruptcy, and the consequences of it are substantial enough that we always issue that reminder. There are things that you can do within the bankruptcy as a landlord that tenants, the most important of which is to address the exercise of certain tenant rights in bankruptcy. And I'll just tick a couple off here. These are the main ones. The tenant has the right to assume the lease that they're in and assign it to some new tenant if it hasn't been expired or terminated by your mutual agreement with the tenant before they filed bankruptcy. I mentioned that earlier. Mutual termination can be your best route to stay in the clear here. But if that hasn't happened, they do have the right to do that, but there are some landlord's rights as well, and you have to assert those quickly if you don't want the tenant to be choosing the replacement tenant for you. In order to exercise that right, the tenant must keep paying you post-petition rent. So they can't just sit on your space and not pay you, even though they don't have to pay you what was due before the petition was filed. So another important thing for you to figure out in seeing what your destiny might be in a bankruptcy with a tenant is your lease at above or below the market? And there, a good broker is your best friend, because what the market is these days is a moving target. So those are my main tips of things to think about in the bankruptcy. I think Jill might have a little bit to add to that, however.
Yeah, and I just sort of want to give a background for landlords, for anyone on this call who doesn't know just the very basics of bankruptcy for landlords. As Carolyn mentioned, the past due rent becomes part of the bankruptcy estate. The future rent they have to pay if they want to assert these rights and stay in the space, or else assign the space. But if your tenant filed for bankruptcy, what happens to you as the landlord is you basically become an unsecured creditor with respect to all of that past due rent. So every secured creditor gets paid first in the order of their security rights. And then there's a big pool of unsecured creditors at the bottom. If there's any money left over after paying off all the secured creditors, the unsecured creditors share in that equally. So you as the landlord and any other creditors to the bankrupt debtor, that you just share. Maybe you'll get a few cents on the dollar, maybe you'll get more, but there's no priority within that. So it's really just important to understand that can leave you with nothing. And it's a time to look at public filings when you're trying to think about, there might be a reason to file a lawsuit, because it might help you to become a secured creditor. If you can get a judgment, or at least in my jurisdiction, California, there's a process called a writ of attachment, where you can go in very quickly right at the beginning of the case. If you've got a contract claim like a lease claim for a set amount and it's clear that they're in breach, you could actually get a writ that allows you to go into line with the secured creditors, makes you jump ahead of all the unsecured creditors. It does cost money, but it gives you a lot of power. Once you get that writ, you have the right to start seizing assets. They're not yours forever, but you can keep them temporarily. And so tenants might be afraid you're going to take their money, that they won't be able to continue running their business. So it's an expensive process, but in certain cases, it allows you to take precedence and to actually get some bargaining position and to get some priority in the aspect of bankruptcy. So just be thinking about what options you have in terms of trying to get your past due rent actually paid if the debtor files for bankruptcy.
Interesting. Rodrigo, from your perspective, tenant bankruptcy, should that affect a landlord's decision making?
Yeah, so actually, bankruptcy can be foreseen by landlords if we have the ability, as we were discussing earlier, to obtain some financial information from the tenants. As Bankruptcy doesn't happen overnight. There are some red flags that you can, when you're analyzing the monthly financial reporting packages. For example, just a high amount of accounts receivable or growing inability to pay their bills on time, decreased sales that has nothing to do with cyclical revenue cycles or seasonality, an increase in inventory, overall potential decrease in profit margins. So there's multiple areas or multiple factors that, as you are reviewing some of this information and developing some benchmarks and key performance indicators for some of your tenants, you can foresee potentially there's something with this company, something's not coming right. Also, there's another factor with bankruptcy that there could be potentially doing the bankruptcy on purpose, right? So fraudulent bankruptcies. Some of the items or red flags here potentially could be if they recently changed their corporate structure. They went from being incorporated to a multi-level LLP, LLCs, now have new parent companies. So really trying to muddy the responsibility of the parent company. Sometimes you also see potentially that there was a big loss in inventory right before the bankruptcy was filed, or there was a theft or a potential warehouse fire. Those are all, again, red flags that we should be looking in. And again, working with your legal counsel, working with your outside accountants, you can definitely start looking at, are there those red flags? Should we be investigating more? And then, as Caroline and Jill were pointing, is truly following the laws and of the bankruptcy case itself. Tim?
Thanks, Rodrigo. All right, let's get on to another question here. What do landlords need to know about collecting unpaid rent? Francisco, let's start with you on that one, Francisco.
Thank you. I think the first thing is communicating with your tenants. I think Rodrigo, Jill, Caroline have done a really good job, and Jill went really deep into understanding your tenant and where do you stand with regards to priorities of payment. So I think the first thing is, in many cities, their tenants required to give their landlords notice if they won't be able to pay their rent due to COVID. But regardless of the different regulations, I think if you have a relationship to communicate with your tenant, he should let you know regardless what that local law is. With regards to understand where you are with the payment priorities, the next one is encouraging tenants to pay what they can. A lot of times we have seen right now how many landlords and property managers and different industries looking at the industry, and instead of doing the traditional drop box, they're setting up electronic payments, and that have increased the collection efforts in some of their operations. So what are they doing for that technology transformation to make sure that if somebody's auto pay, most likely the person is going to pay every month? And instead of trying to go and cut the check and go to the mail office and pick it up. So understand where we are with this pandemic and how can we improve that. And I think the last thing is really trying to get financial data to really understand and validate some of the statements from the tenants and see if you can put some pressure to collecting some of those rents. Thank you, Tim.
Not for the legal perspective, Caroline, what do landlords need to know right now about collecting that unpaid rent?
So, Tim, traditionally the way that a landlord will collect the rent is to join with any claim for possession in an eviction action, their claim for the unpaid rent. And that has the advantage of quickness, because the possession claim will be tried quickly, and with it, that past due rent claim. That might not be available if the moratorium is getting in the way of it. So to collect the rent, the landlord can also consider whether to file a case outside of the eviction court, but that's a slower process. One of the things that's tricky always, but particularly in this environment, is forecasting with the landlord about whether it's all going to be worth it no matter what you do. And I would just make a pointer here that it's always a game of guesswork about what assets the tenant has if you don't have access to information in the underwriting process when you entered into the lease or at the time, at the current time. But eventually you will have discovery tools, subpoenas, the power to get documents, bank statements, banking information, and so forth. But you have to make an investment to get there. One little myth I'd like to dispel, because it's would be too good to be true, and unfortunately it's not usually the case, that you can get bank account information from a tenant if you don't already have it, because that's protected by law. So one little practical tip I throw out there is if your tenant's actually paying by check or in the ACH transmittal information, you can get banking information out of that, latch onto that and keep it in a file somewhere, because it's actually worked for me in the past to identify where that banking relationship is, if there's anything there to be gotten to pay the debt for unpaid rent. Jill has a little bit more to say about this topic as well. Jill?
Yeah, so I think the first thing that I would say, and this fact sort of permeates all of the decisions you've been making up to this point, but if your tenant is a single purpose entity, then they're probably going to close down their business and they're going to have no assets to collect from. And so collection can be very difficult if your tenant doesn't have other assets and if you don't have personal guarantees or letters of credit. But in the case where you might have an individual on the hook, either through a personal guarantee or through the lease, there are some tools that you can use in litigation that can be pretty terrifying to a commercial tenant or even a residential tenant. Commercial is the worst case scenario. One big one is what we call a debtor's examination. It's like a deposition. And after you've gotten a judgment or after you've gotten that writ of attachment that I told you about, you can force somebody to give you every financial document and answer every very private financial question. And the courts make them answer those questions. You get to ask them about all of their assets, all of their debts, all of their future income, inheritance expectations, things that they've spent their money on. It's very intrusive. And a lot of times, once you notice that debtor's examination, your tenants will come back and want to negotiate with you rather than have to go through that process. The other point I would like to make is that if you do have a solvent tenant, your judgment for that past due rent is going to accrue post-judgment interest. So let's say you get a judgment for whatever it is, a few $100,000, let's say. In California, that would accrue interest at the rate of 10% per annum. And it varies from state to state, but 10% in this market is an incredible return. And you can basically just sit on your judgment and it'll keep accruing interest until you finally get that money. So if it really is a solvent tenant, you might even want to, you don't necessarily want to sit on your rights, but you don't need to worry about not getting every last penny up front. So that is the other point I would make too.
Got it. We are starting to see a lot of questions come in from the audience. And, so I go with the panel, I think we'll move on to those. All right. The first one we have is, if you don't have a right to audit and it's not a public company, how can you determine if the tenant is telling the truth, i.e. the need for deferral or forbearance? Francisco, why don't we go to you on that one first, just to put you on the spot.
Thank you, Tim. I think is the first thing that we will do is understanding what the lease agreement says and what rights do we have. Once we understand that, we can request information from the customer. Again, we say these are unusual times, so if they want to relieve, we can, as part of the negotiation, we can ask something on exchange and start looking at bank statements, because the bank statements are going to, especially for those what we call the general operating account, it's going to tell us all the cash coming in, and it's going to tell us payments going out. So we will be able to say, hey, are they moving cash out of the company? But I will start with the basic financial statements, and I will look at the balance sheet and the income statement, and it will be for a comparative period before COVID for the most current calendar year, and then I will look at it for year to today to understand where they are post-COVID.
Interesting. We've got another question that just came in. How soon should you cash a security deposit when a tenant defaults? I.e., if you sue the tenant for not paying rent, you might lose the suit and the ability to cash in the deposit. Caroline, did you want to take a stab at that one?
Sure. The answer to the question of when you should cash a security deposit sometimes turns on what your outcome is that you would like to achieve. If your goal is to get the tenant out of this space, then leaving the security deposit where it is means that they have uncured rent defaults, and that can be the basis for seeking your judgment of eviction. If you apply the security deposit, you have then potentially cured the defaults if it covers them, and then you don't have that basis to get them out, although another basis might exist or come along. So that's one way of approaching it. The other piece, which is a little more complex, and I'll just put a bookmark down, is that there can be implications in bankruptcy. It's a little more complicated. So if you think your tenant is headed for bankruptcy, that's something where you've got to dig through a few more layers.
Gotcha. Let's move on to another one quickly. How will leases change in the future as a result of what landlords are experiencing during this pandemic? Jill, do you want to start with that one?
I would love to take this one. This one's near and dear to my heart at the moment. Thank you to the questioner, and thanks, Tim, for batting it to me. The reason I love this one is that, for instance, Caroline and I are litigators. We try cases. But what we're spending most of our time doing right now is keeping people out of litigation and doing the negotiations and not litigating and trying to help you figure out these solutions and then documenting the agreements. And documenting your settlements is one thing, but your question is right on, that leases in the future need to be different than leases in the past. And a really good example of this is, I'm sure most of you will remember, when the quarantines first hit, the term force majeure was being thrown around as some sort of a magic bullet for tenants to get out of their leases. We were getting a lot of calls from landlords worried that that was the case. For the most part, it's not that easy, but it required an intensive analysis of the lease terms and then sort of speculating a little bit about how courts would treat those force majeure provisions in this particular pandemic. The key of force majeure is that it has to be an unanticipated and unforeseen event. And that's the issues with coronavirus and quarantine, this pandemic, a future pandemic. They are no longer unforeseen. And so your force majeure clauses aren't really going to apply. You have to include in your leases what will happen if there's a government shutdown. What will happen if there is a quarantine? What will happen if there's some other kind of pandemic that affects your tenant's ability to use the premises? Those things used to be unstated. They have to be so much more clear now. The other thing that you might want to consider putting into your new leases also relates to everything we've been talking about, which is these financial rights. In the past, most leases don't require your tenant to give you too much financial information unless there's a percentage rent obligation. And so new leases might want to contract for detailed financial disclosure obligations in the event that a tenant falls behind on the rent. So those are a couple of examples, but I absolutely do think my rule previously applies. Don't just cut and paste your prior lease. Think about how things have changed given what we know now.
Got it. I feel like I thought I heard somebody talking. I haven't put Rodrigo on the spot yet. So, Rodrigo, when it comes to forensic analysis, how deep does it go? Can you kind of talk about that process?
Absolutely. So the answer, which is the true accountant answer, is it depends. right? It truly depends on the scope and working with the legal counsel, right? Because at that point, we are being engaged by your legal counsel and working together with assisting your legal team with their exhibits and the information that they will need. So it truly goes back to the same topic and the same rhetoric we're discussing. Do we have those financial information from the get-go? So if we do, then the process will be expeditiously. It will be really easy to obtain information. If we need to go through subpoenas and request documentation through your legal entity, then that will require a little bit more of the analysis. But it just depends on the time frame, how many units, how many different tenants are there. It truly depends on grasping the scope in that sense.
Got it. And let me keep you there for a second, just because I got another question I know you can answer. Mm-hmm. Are there any risk assessment tools a landlord can use to forecast potential impact?
Interesting question. So there's nothing specific right now out there that would address the landlord situation with COVID. However, there's uniqueness in everything, right? There's many tools out there that address risk, that address forecasting, that you can definitely apply and that add this layer of complexity that is the volatility and the uncertainty. So I think it goes back to really understanding who your tenants are, understanding the industries that they're focused on, understanding the payment history, and applying that information into a risk model that will allow you as a landlord or you as the operating company to address those different factors.
Got it.
Tim, this is Francisco. I would love, Rodrigo was going down the path. I think it's important for the audience that we have either Jill or Caroline explain the importance, if we're going to go down the forensic path or we're going to go down the fraud examination, why the importance of the client attorney privilege, and why, how do we go about that process? Because it's very important if we decide to do it the independently versus going as a contractor of the attorney, and that way we secure that attorney-client privilege. If Jill and Caroline could expand on that, I think it will be very beneficial for the audience.
Sure, be happy to, Francisco. Just to put it very simply, under the right circumstances, when we as legal counsel hire or engage the accountant or the forensic accountant, a forensic examiner, there can be a privilege that attaches to the results of that analysis. There have to be the right conditions, and the engagement has to occur in the proper manner, to put it sort of oversimplified, but the result of it is something that can be very beneficial to the client. And just to be blunt about it, you get a sneak peek at what the results are before you put it out there to your adversary. That's the kind of the high level view of why it's can be beneficial, but you have to figure out whether in the circumstances that's available. And when I say engage the accountant, it doesn't necessarily mean we choose them. We choose them with our client, but when we are the vehicle for engaging them. So it is completely at the client's discretion as to who to engage, if anyone. I hope that answers.
That sounded great. Jill, anything to add to that, or did Caroline pretty much cover it?
Caroline nailed it.
I knew it. So we're running out of time here, and I just want to wrap things up and thank Jill, Caroline, Rodrigo, and Francisco for joining us, and obviously the audience, everybody for coming in and listening to our webinar today. We do have your contact information. We're going to send out some ways you can get in touch with us if you have any additional questions or would like to learn more about the topics we covered today or anything else. So be sure to reach out that way. Again, if you have questions, feel free to reach out to us via email, and we'll follow up. But I do want to thank everybody, and have a great day.